to sacrifice in a world not of their.
Jean-Jacques Rousseau once wrote, "In the strict sense of the term, a true democracy has never existed and never will exist." Good evening and welcome back to the Human Rights Enigma in the second segment of our series. Tonight we're going to take a look at and to discuss the real interplay between international human rights laws and our own domestic law and court process. Few would doubt that the framers of the U.S. Constitution, influenced perhaps by 18th century Age of Enlightenment thinking and their own experience in breaking free of the fetters of the British monarchy, developed that extraordinary document with its amendments with a powerful emphasis on the protection of the rights of the individual. They realized that a balance had to be struck between the rights and interests of the individual and the state, and between the individual, the local state, and the corporate state of the nation. No mean task in the face of what was potentially a very complex set of competing interests, rights, and needs. In fact, the framers devoted much time and energy in devising a judicial process that in the main we rely on 200 years later. The framers even had the foresight to provide within this system of law for the jurisdiction to adjudicate matters under Article 3, Section 2, related to cases and controversies between the citizens of one state and citizens of another state, and citizens of the United States, and citizens, subjects, and foreign nations. And though the Constitution itself does not refer to international law, known as law of nations, the very first Judiciary Act of 1789 certainly does under Section 13 of the Act. In addition, the passage of the Alien Tort Act of 1789 seems even to have extended those rights afforded U.S. citizens to aliens, which is a remarkable fact in itself. However, even the formidable minds of Jefferson, Paine, Franklin, and all of the others were not entirely free from the prejudices and customs of their time. And in the midst of all of this incredible progress, slavery flourished as a degrading and inhumane institution all through the Americas, North and South. And it wasn't until 1865, under President Lincoln, that this iniquitous state of affairs was addressed in a bloody and savage internecine conflict that pitted the states of the North against those of the South. We call it the Civil War. And from it emerged the Civil Rights Act, a landmark document in American history, legally abolishing slavery as an institution. But, as we Americans are all too aware, the next 100 years brought only injustice and lack of implementation of this civil rights law, as well as the sorrow and the shame that these circumstances have brought upon our nation. While we actively regaled other nations for their lack of democratic process, we busily denied to our own people the most rudimentary elements of the rights of citizenship, their dignity, and in the modern sense, their human rights. All of which brings us to tonight's distinguished guests. First is Howard Glickstein, Dean of the Jacob Fuchsberg Law Center of Touro College. Dean Glickstein is admitted to the bar of the U.S. Supreme Court. He has been staff attorney in the Department of Justice, general legal counsel of the U.S. Commission on Civil Rights. He was one of those responsible for drafting our Civil Rights Act of 1964 and the Voting Rights Act of 1965. He is also a former director of the Suffolk County Human Rights Commission. Next to Dean Glickstein is Elsa Stomatopolou of the United Nations Center for Human Rights. Elsa has been with the UN since 1980 and became chief of its New York office in 1986. She is a member of the UN Panel of Counsel defending cases before the Administrative Tribunal, and she has lectured widely on a variety of human rights issues, including implementation of human rights conventions, the rights of the child, and indigenous peoples. Last but not least is, on my left, is Malvina Halberstam, professor of law at the Benjamin N. Cardoza School of Law, Yeshiva University. She's a former consultant to the State Department and counselor on international law in the Office of the Legal Advisor. She is the author of numerous articles and monographs on human rights issues, foreign relations law, the Arab-Israeli conflict, and women's rights. She is without doubt an acknowledged and an outspoken expert in the field. Well, good evening to you all, and thank you for being here and joining us. I think to start, I'd like to start with a proposition that you might agree with or not agree with, and that is the following, that there is a general perception amongst the public, the people out in the street, that they seem to have lost all faith in the legal system and the idea that one can possibly obtain substantial justice from it. And with that in mind, I want to throw a quotation at all of you for comment. The early 19th century writer Frederick Bastiat once cynically wrote about the law in regard to the natural rights of individuals and lawful defense of liberty and property that, and I quote, "The law has been used to destroy its own objective. It has been applied to annihilating the justice that it was supposed to maintain, to limiting and destroying rights which its real purpose was to respect. The law has placed the collective force at the disposal of the unscrupulous, who wish without risk to exploit the person, liberty, and property of others. And it has converted lawful defense into a crime in order to punish lawful defense." Malvina, let's start with you. In general, what do you think Bastiat means? Is he saying that the law is nothing more than a tool to be manipulated by those who are enfranchised, those who are in authority, those with political and or economic clout?
I don't know what he means, but it seems to me like a very negative comment on the legal system. And while I think there are a lot of problems with the legal system, and it needs to be corrected in many ways, there are tremendous delays in the court, there may be more substantial problems, I think the legal system in the United States is also one of our prides. The basic belief of most Americans still is that if something is wrong, they can go to court and get it rectified. It's almost a colloquialism. If you don't do this, I'll get a lawyer. If anything, we litigate too much. And we wouldn't litigate too much if we didn't believe that we could achieve justice through litigation.
Dean, let me ask you then. I mean, is it possible that we have, in collating this massive amount of law, have we managed to construct a number of barriers over which litigants must climb in order to obtain justice? And I'm thinking procedural, administrative barriers.
I agree 100% with what Malvina just said, and I guess most lawyers probably would agree with that. I think
I can disagree. I'm not a lawyer.
Because our society tends to be so litigious, you have to have some rules to play by. And we have procedural rules, administrative rules that direct when people can go to court, when they can sue, and how they can proceed, and those generally are necessary. But I think that most people do have access to court. I think, unfortunately, there are trends today to limit people's access to court, to limit people from suing and to rectify injuries from product liability, to limit people from suing to rectify damage done to them by medical institutions.
Yeah, these are issues, in fact, I think we're going to be taking up in a later show when we deal with access and petition to the court. But it is interesting, parenthetically, to note that somebody can burn their lip on a cup of coffee at McDonald's and sue for $20 million, and yet when a controversial issue is brought before a court, it looks for ways to drop the litigation. It's just very interesting.
But on your quote, I think the quote really is a variation of whose ox is gored. I mean, people who believe that they have a right to have as many guns as they desire believe that the law is suppressing them, that the law is inhibiting them because it prevents them from doing that. People who once believed in polygamy feel that their natural right to have as many wives or husbands as they wanted is being inhibited by the law.
All right, let me turn your attention to another side of the coin and ask Elsa what the UN view might be on this. Do nations, especially the Western ones, encourage or discourage the recognition of international human rights law and or inhibit the seeking of a remedy and redress for violations?
Well, I wouldn't put it in terms of Western states versus other states. In fact, that's the point of the UN. We are there together, all countries from different parts of the world, from north, south, east, west, and we set the limits through human rights law between the individual and the state. That's the whole point. So I would say that through our work, basically, we try to to establish those limits and to create a certain awareness amongst citizens or human beings that they have what are the limits that the state must not transgress, and what are also the obligations, the positive, specific obligations that the state has towards them in terms of their
you would
human
agree
rights.
with Neil Afrin and Martin Flaherty's view, which was expressed in our first program, that there are both positive and negative aspects to human rights.
And I would refuse to put it in terms of, to put human rights law in terms of the Western doctrine and the Eastern doctrine and the Southern doctrine, because in fact what we have done over 50 years of work at the United Nations, and especially in standard setting, in saying, in other words, what are human rights, is to bring together all these views by consensus. That's another interesting element. What are those rights? And we now have this body of law that expresses all of us.
Okay,
so whether you talk about East and West or North and South, different countries in the world have a different concept of what they mean by human rights, I think. I think in this country, when we talk about human rights, we usually mean political and civil rights.
Yes.
In other countries, when they talk about human rights, they often mean social and economic and cultural rights.
Well, hold on. Let me, because I think we're getting to a very interesting area here, because this program is set up to discuss two sets of rights. The civil rights that we Americans are used to describing and talking about, and human rights, which most Americans seem to be very unfamiliar with. So let me ask Dean a question after I give him a quote. I'm going to quote from a very familiar document to you. You helped to draft it, Civil Rights Act, where it said that every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proceeding for redress. Now, one question I really want to ask, it's been on my mind for quite some time, is, Dean, can a violation of a U.S. civil rights nature also be a violation of human rights law?
Well, first of all, I just want to mislead our audience. That law was drafted in 1871, and I wasn't around at the time to participate in that.
But I mean, that still holds true.
But that's still part of our laws. Yes, it's now called Section 1983.
Right.
And there are various types of litigation in this country where people can sue under that for a violation of what we would regard as a civil right that's also a human right. The right to free expression. Somebody that is denied free speech can sue under that statute, and that would also be suing for the violation of a human right. On the other hand, somebody that felt that they were denied an adequate education by the federal government or denied medical care probably couldn't sue under that, because there isn't a right in this country to medical care or a right to an education under federal law.
Right. Malvina, you...
Yes, I wanted to note that most of the rights in the Covenant on Civil and Political Rights, which the United States helped draft, but did not ratify for many years, but now has finally ratified, are parallel to provisions in the U.S. Bill of Rights. In fact, when I teach international law, I ask the students to find the parallels. The Fourth Amendment is there, the Fifth Amendment is there, the First Amendment is there, all those provisions with somewhat different language perhaps, but really very strongly paralleling our Bill of Rights. So much so, in fact, that when the United States ratified the Covenant on Civil and Political Rights, we did not enact implementing legislation, and the statement was made that it wasn't necessary because we already have everything in our laws. I don't agree that we have everything, and I do think we should have some implementing legislation, or we should make the covenant self-executing, which would mean people could go into court and simply use the covenant as American law. But I would say probably 90% of what's in the Covenant on Civil and Political Rights, which is one of the basic human rights documents internationally, is already in the U.S. Constitution and the laws that have been developed to implement it.
Just I want to add, to make it very clear for our audience, that of course civil and political rights are just one part of the human rights family. We have also the economic, social and cultural rights, and sometimes people also talk about the third generation rights, such as the right to development, which is a very big subject right now. At any conference at the United Nations, you discuss very much this right, or environmental rights. This is the new generation of human rights we're talking about.
Those are actually sometimes often, they're included, I think, under, is it 23 or 24 of the ICCPR, under what is normally privacy and family. I've seen cases brought before the Commission.
Well, I was not referring to those, in fact. I was referring to the Covenant on Economic, Social and Cultural Rights, to the Declaration on the Right to Development, and other documents.
I have a great problem with referring to some of the rights in the Covenant on Social, Economic and Cultural Rights as rights. And the reason I say that is I think it tends to undermine the concept of right. At least in the United States, when we think of a right, we think of it as something that you can get, and if somebody denies it to you, you can go into court and demand it. So if you have a right to vote and you're denied the right to vote, you can go to court. Or if you have a right to counsel, you're denied the right to counsel, you can go to court. The Covenant on Economic, Cultural and Social Rights has provisions such as everyone has the right to the highest standard of living. Everyone has the right to the highest standard of education. What does that mean? Does that mean that if a state ratifies that covenant, it obligates itself to provide everyone those standards? The covenant also provides everyone has a right to work. Those are very nice ideals, but they're not legal rights and cannot be implemented in the same sense as the civil rights or political rights can be. And I think by labeling them rights, you diminish the meaning, or you somehow give less power to calling something a right. So I would like to distinguish between the two. And the United States hasn't ratified the Covenant on Economic, Social and Cultural Rights, and I'm one of the people who has been very strong for our ratification of all the other covenants, but not of this covenant, because I think those should be goals. That could be a declaration of purposes.
I know that Elsa might disagree with this, but I think that what Malvina's just said is really a Western concept. It could be a right. All that you just, if the state were prepared to guarantee it, it could be a right.
Well, if you say we have a right to work, for example, does that mean the state has an obligation to give everybody a job?
Under some state constitutions, there is a right to education. It's not under the federal constitution.
A right to education I have no problem
and that
with.
Is provided
the problem I have with is a right to the highest standard of education. What does that mean?
That's a goal.
That's right, that's a goal. It should not be in a covenant. Exactly. Yeah. The point is this.
Well, let's bring Elsa in. I think we better have a UN spokesperson.
Let me just finish one sentence on this. The point with all these things is they may mean one of two things. If they mean that these are goals that we want to achieve, that's fine, but then that's not a treaty. A treaty, like a contract, should be an obligation. If what they mean is that there is an obligation, then what we would be talking about is enacting a socialist form of government. If the government has an obligation to give everyone a job, do we really want that? And I'm not saying we do or we don't, but I'm saying we have to consider it.
But what if we ask the question not in terms of work and employment, but in terms of, if I pose the question to you in terms of health and medical care. Many of the states in Europe provide health care to their people,
yes.
and that seems to be a very fundamental need of the human race.
I'm not saying it's right or wrong to do that. I'm just saying that if we ratified something like the Covenant on Social, Social, Economic, and Cultural Rights, we would be doing one of two things. We would be saying these are just goals which we hope to attain, and we're working to attain them, which is, by the way, what all the states do when they file their reports. Every state files a report saying they're doing wonderfully under these covenants when they're not. Or we would be saying these are obligations, which is normally what you mean by a treaty. And if they are obligations...
let's bring Elsa in
then
there. She's champing at the bit. Let's give her...
Well, then we should be saying we want to adopt socialism. You mentioned Europe. A lot of the European countries have a socialist form of government. I'm not expressing an opinion on whether it's right or wrong, but we have to be aware of where we're going.
In
Elsa.
fact, the opinion that Malvina just expressed has been expressed very often by the U.S. delegations at the Commission on Human Rights. This is the distinction that they've. But there is a very basic distinction between these two families of rights, which we recognize as rights, and I underline it, not just goals. And the distinction is that economic, social, and cultural rights are progressively implemented according to the economic standard, the economic capacity of a country. For example, the right to education cannot be implemented at the same level by a rich country like the US and a poor country like Zaire. But it doesn't mean that they can get out of their obligation, their legal obligation under international law, to take measures, to adopt policies towards the implementation of those rights. That's what we say in our analysis. Nobody says, for example, that right to housing, I mentioned this because we have the Habitat Conference in June in Istanbul. Nobody says that right to housing means to give everybody a key to a house, but it means adopting measures that will make everybody have some basic housing. That's what
Yes, but what kind of measures? Can you be a little more specific? In other words, if something is a right, we ought to know exactly what it is that you have a right to. What does the right, supposing I'm living in the United States and I don't have a house and I don't have anywhere to live, what, if the United States ratified this treaty, what would the right to housing entitle me to do? Let's say it was self-executing. Could I go into a court and say what?
Yes, in fact, the Dean showed to me before the program started a very interesting document prepared by the Commission of 1968 that was established to celebrate the International Year of Human Rights, in which the US says what they're doing on the right to housing. I explain. For instance, if there is, for low-income families, for instance, you give some subsidy. If there is no available housing at the rate that they can afford, you give some subsidy. Or you try to build housing of a certain level which is affordable for these families. You know, it can be subsidized by the city, the municipality.
No, I'm not asking what can be done. I'm asking what you're obligated to do. We now have a tremendous problem in the United States. There are hundreds of homeless people in the streets. You know, I'm a refugee to this country, and when we came to the United States in '47 as a child, I remember what my parents commented on, the difference between the United States and every other country that they'd been to. There were no people in the streets begging or living in the streets. That, unfortunately, is no longer true. Well, I find it heart-rendering. If we had ratified this convention, would we be violating the law? Would one of these people have a right to go to court and say, do something? Because if not, then ratifying the convention is meaningless.
Well, I wanted to ask a question here, because I think we need a clarification for the audience. I know this could go on forever, but I think we better, move along. The first question I would have is, could you explain, all of you, what the difference is between a treaty that's executing and one that's self-executing?
No, it's a treaty that's self-executing and a treaty that's not self-executing.
Yes, exactly. Okay. Exactly. Sorry.
I'll be glad to do that.
Thank you.
A treaty in the United States, the Constitution provides that all treaties are the supreme law of the land, just as it provides that statutes are the supreme law of the land. Right. Now, if a statute is violated, someone can go into court and try to get a remedy for its violation. However, early in the history of the United States, going back to Justice Marshall, we seem to distinguish between treaties that were self-executing, which meant that as soon as they were ratified, they became the law of the United States, and treaties that were not self-executing, which meant that before they became law domestically, the Congress had to enact implementing legislation. I have some question about that constitutionally, and I'm in fact doing some research on the subject. But the black letter law that's generally accepted is that if a treaty is not self-executing, we're still bound internationally, but you cannot go into a U.S. court and invoke a provision of the treaty in the same way as you can invoke a provision of a statute.
Well, okay. Well, I want to change the subject here, but in a sense, I want to bring it back full circle to something that you said. You said that you came to this country as a refugee. And this, in fact, raises some questions for me, and I have in mind a recent case, the Haitian counselor's case before the Supreme Court, in which boatloads of refugees have been turned back to Haiti without their ever touching base here in the U.S. And I really wanted to know whether this raises any questions of violation of international law under customary international law or specific human rights agreements. Have we violated anybody's rights in returning these people on the high seas?
I think it does. What the United States did is far worse than not admitting these refugees. We seized Haitian ships on the high seas and forcibly took them back to Haiti. So here were people who are trying to escape from Haiti. We say for economic reasons, they say for political reasons, but regardless, they were risking their lives to leave Haiti on these wobbly little ships, and the United States government forced them back to Haiti. This has been contrary to everything the United States has stood for until now. The Universal Declaration of Human Rights provides that everyone has a right to leave any country, including his own. The Covenant on Civil and Political Rights, which we've ratified, provides that everyone has a right to leave any country, including their own. And in the United States, domestically, we had long supported those rights, even before we ratified the Covenant, to the extent of enacting legislation, which was known as the Jackson-Vanik Amendment, I believe, to our trade laws, which provided that if certain states prevented their citizens from leaving the country, we would deny them various trade rights in the United States.
Elsa, do you want to jump in there?
I just want to say that the Universal Declaration provides that a state, a government, should not return to a country people who fear persecution because of their beliefs or their color, race, and so on. So in that sense, if of course it is a violation if there is such a fear of persecution if a government does that. And the US, I suppose, in this case, might have not followed all the legal...
All right, well, quickly.
May I just get in for 1 second, because
hold
I
on,
think there was a mistake here.
Malvina, okay, I know, but we're running very short on time. I want to get the Dean's view on this. Dean, I mean, were there we know their human rights may have been violated, but were their civil rights also violated? Was there a lack of due process in treating them that way?
Obviously there was, because of what happened on the high seas. I think that the point here is that the United States often enforces international law for its own political reasons. If it would have
it's
been
selective, you're saying.
If it would have been advantageous to admit people to this country to demonstrate that the country that they were coming from was doing something awful, we would have been very happy to admit them. But because we didn't want to raise an issue with Haiti, we turned them back. The Jackson-Vanik law was passed to maybe embarrass the Soviet Union that would not allow Jews to emigrate from Russia.
But it was effective.
And it was effective, yeah, it succeeded. But,
and we've now done it not only with Haiti, but we've also entered into an agreement with Cuba, which was labeled as a major success of the Clinton administration, that Cuba would prevent its citizens from leaving. And I wanted to correct one point, because the Universal Declaration doesn't make it contingent upon them being a fear of persecution. It says, and I'm reading from Article 13 of the Universal Declaration, everyone has a right to leave any country, including his own. It does not make it depend on whether they fear persecution.
Well, look, let me stop you. Let me stop you all there and give quickly, in 20 seconds each, a summation of this discussion. Where are we going with human rights in our country? Dean, quickly.
Well, I think that in the United States might be going somewhat backwards in the field of human rights. I think that to the extent that the UN Declaration of Human Rights, for example, talks about people's right to cultural and art, we are about to eliminate the government support of the arts and culture to a large extent.
Well, I see we're out of time. I'm going to have to cut you all off there. It just remains this evening to thank our special guests, Howard Glickstein, Malvina Halberstam, Elsa Stomatopolou, and I'm certainly hopeful that you'll tune in for the next show, which is going to deal with children's issues, matters of divorce, custody, and family rights from a human rights perspective. As is our custom, I leave you with a parting thought or two and return to the author of The Social Contract, Jean-Jacques Rousseau, who wrote, "The strongest is never strong enough to be always the master unless he transforms his strength into right and obedience into duty." And at length I recollected the thoughtless saying of a great princess who, on being informed that the country people had no bread, replied, "Let them eat cake." So from the Human Rights Enigma, I'm Stuart Ryan. Good night, Godspeed, and be ever watchful of your rights.